This is Agriculture Today. We are back now with Roger McEowen for our bi-monthly ag law update. So Roger from K-State and Washburn University School of Law, he's going to be supplying us with that information today. So Roger, thanks for joining us.
It's always good to be with you.
Well, let's start off with this first story that you've recently wrote about. The IRS has recently modified a portability election rule. Can you explain a little bit of that modification for us?
Yeah, this has to do with federal estate tax. And a number of years ago, back in 2010, there was a law that was passed that said for decedents' estates and for deaths after 2010, so starting in 2011, that we had this new concept that we had never had before with respect to the estate tax, and it was known as portability. And what that does is for a married couple, if you have any unused federal estate tax exemption equivalent amount at the death of the first spouse, you can port that over, transfer it over to the surviving spouse, and they can add it to their exemption. And that's a big deal. The current level of the Unified Credit Exemption equivalent is $12.06 million for deaths or gifts made in 2022. And that's per person. So in a married couple, the husband has his $12.06 million exemption amount from federal estate tax. The wife has her $12.06 million. So over both of their deaths, under current law, there's $24.12 million that can be shielded from federal estate tax. So there are really very few estates. It's a fraction of 1%, Samantha, of all decedents' estates that are actually subject to federal estate tax. When it applies, it's a big deal. But that amount is set to come down to $5 million adjusted for inflation in 2011 dollars, starting in 2026. So the ability to port over any unused amount of the exemption for a smaller estate to a surviving spouse is really a big deal. And just to put some numbers on that, let's say that I've got a farm or ranch operation in Kansas and it's worth $5 million, and there are a lot in that category. Well, there's no federal estate tax liability under current law because the exemption is $12.06 million per decedent, per spouse. But what if that exemption level comes back down to $5 million in 2026, and now your values have gone up to $7 million? Well, you've got that extra $2 million that would be taxed at 40%. So that's a really big chunk. Mm-hmm. Well, if I can take any exemption that I left on the table at the death of the first spouse and transfer that to the surviving spouse, I may be able to eliminate the tax on that $2 million of excess value at the death of the surviving spouse. That's why this is a pretty big deal.
Absolutely, and I think you also highlighted why it's a big deal because we talk about the cost of farmland going up every year, and we can only anticipate that to continue really from here, right?
That and asset values in general. And if you take a farm or a ranch that is uniquely positioned on the edge of an urban area, say around Wichita and the Kansas City area, even around areas such as Topeka or any type of urban area, we could see this impact even in areas out near Salina in central Kansas. You would price pressure put on that land because of developmental potential. And so that gets reflected in your estate tax value. Now, there are some other things that we can do from a planning standpoint to deal with that type of situation. But if you don't take those steps, then you've got that increased value, let alone from what the ag land market is doing. So, yeah, land values could go up, and if Congress lets the law stay where it is right now, that exemption is going to come down. And could see more estates that are subjected to federal estate tax in the future. That's why portability is really important. And for the estates that don't have to file a federal estate tax return because there's no tax, they can make this portability election by filing a 706, a Form 706, which is the estate tax return in the estate of the first spouse to die. Check a box, fill out some other paperwork associated with that return, and port that over or transfer that unused amount so that the surviving spouse can add it on to his or her own amount.
Sure, and before this rule it was like a 2-year period that you had to do this, right? And they've changed that to now where it's going to be 5 years?
Yeah, that was the recent announcement by IRS just less than a couple of weeks ago. Yes, there was a 2-year rule that was set forth from the date of the death of the first spouse to make that portability election in that first spouse's estate. And IRS has now extended that to 5 years from the date of death of the first spouse. And I think they did that for a couple of reasons. One is they're extremely understaffed in the estate and gift tax area. And if you're dealing with all of these small estates needing to make a portability election, you simply can't keep up with the processing of it, let alone income tax returns that they're woefully behind on processing. They're streamlined, but still there's a lot of confusion amongst taxpayers as to how these rules actually work. So they just said, all right, you got 5 years to do this instead of 2, and I think they're hoping that reduces their workload on this.
Sure, a lot of paperwork involved, especially when you talk about the complexity of some people's property and ownership, for sure. So thank you for that update on that change. It's an important one for listeners to keep in mind, for sure. Let's move on to this next story that you've recently brought up, and it's one where it's an auto accident, but there was also an already dead animal in the road. Can you explain it a little more for us?
Yeah, this happened out in the Goodland, Kansas, 40, 50 miles inside the Kansas border, or actually a little bit less, or the Colorado border. This happened about 4 years ago. And you had a pickup truck that was westbound on I-70, headed from Indiana out to apparently Colorado. And the truck hit a deceased bull in the roadway. The bull had already been hit a couple of times, and it's laying in the roadway. And these people come upon it, testified that later, court case, they had their crew set at 80 miles per hour. They hit this bull in the night, and the pickup truck rolls. And they got injuries, and so there's a lawsuit back against the Kansas Department of Transportation as well as bull's owner. And a couple of principles come out of this. This case is not resolved. This is just a trial court opinion that said we're not going to grant a summary judgment motion and let this case go on to trial. Now, it was granted in part with respect to the Department of Transportation. And so the court said the Department of Transportation, their fence that they had up does not have to be a legal fence. It has to be a fence that restricts vehicular traffic to the interstate. And so they had no duty to build and maintain a fence to keep livestock off the interstate. And they didn't fail to remove the bull in a reasonable time after they were notified. And so the court said there weren't any fact issues with respect to the state's involvement in this. So the Department of Transportation's out. Then the question was whether the bull's owner could be dismissed from the case. And the rule in Kansas, and many of the listeners will know, is that a livestock owner in Kansas is not necessarily responsible for injuries or death that their animals cause if they escape their enclosures. The injured party has to prove that the livestock owner was negligent.
Well, you hinted at something key there, that's the law in Kansas, right? In other states, there's some variability on this sort of law.
Yeah, this is a different state to state. Many of the major livestock production states will protect the livestock industry with that type of a rule. There was a prominent case 25 years ago out of Nebraska where a theory known as res ipsa loquitur was used, and that basically flips the legal presumption around, and it says, well, you are presumed to be liable when your animals get out and cause injury or damage, unless you can prove that you weren't negligent, which is next to an impossible standard for a livestock owner. So most states, and Kansas included, does not follow that rule. But Nebraska has in the past. They've modified it a bit since then. But some states create a rebuttable presumption of negligence. There are a couple of states where you are liable as a livestock owner if your animals get out and cause injury. But Kansas is not that way. In Kansas, the injured party has to prove that you as the livestock owner were negligent somehow. In other words, you left the gate open. You knew you had, say, animals in heat that had been escaping. You knew that an animal was out and you did nothing to get it back in within a reasonable time, so forth and so on. So there has to be evidence that the injured party brings forth in order for the livestock owner to be held responsible.
Sure, and in this case specifically, the plaintiffs are claiming that the defendant failed to exercise that due care, that they were being negligent because they didn't fix a fence, a broken panel, and they didn't have no trespassing signs. Is that right?
And they also claim that there was an unknown trespasser on the property, and it was that trespasser that allegedly released the bull. So you got all these types of issues in controversy, or facts in controversy, including the maintenance of the fence and whether that broken panel was fixed and whether there should have been no trespassing signs. And ultimately, the court said, well, there are facts that remain in dispute on the negligence issue. And this comparative fault issue of the driver going too fast is also an issue that the court said we're going to have a jury decide these issues. So while summary judgment was granted to the Department of Transportation, removing them from the case, the bull's owner was not removed from the case, and it proceeds to trial.
Well, definitely a complex case for sure, and one that it's always a good reminder for producers to make sure that they're keeping their fence lines intact and to know their rights as property owners and things of that nature. So, Roger, thank you again for this timely information.
Thanks, Samantha.
Once again, that was Roger McEowen. He is a K-State and Washburn University School of Law Ag Law expert with this week's Ag Law Update.